Welcome to our special education, communication legal education class. This course is brought to you from the UNLV William S. Boyd Law School and also the Legal Aid Center of Southern Nevada. My name is Crystal Washington, and I will be facilitating a 6-lesson session today on special education. And we also have our attorney from the Legal Aid Center, Jonathan, on the line as well. So we do have a few goals that by the end of this training, you should be able to know important terms like FAPE and IEP, have an idea of how an IEP is created and what it does, get an expectation of how placement and practices work, and understand your safeguards and parental rights. So getting into lesson 1, it's really the definitions and history. So what is special education? So the eligibility for a Section 504 and the IDEA or IDEA is, we're going to start here just in the center so we can understand it a little bit better. So the IDEA is children who have one of 13 IDEA disabilities and who need special education services. And these children also receive an IEP, which we'll get into a little bit later in today's presentation. That next section that looks a little yellow-orange, that is for Section 504. So this is actually with children with physical or mental impairments that substantially limit a major life function. So slightly different from the IDEA. And these children would have a 504 plan and not an IEP. And that green section represents all children with disabilities, so it would include the others. And then we have that outer blue circle, which is all children. So our federal laws, policies that protect the rights of children with disabilities are listed here below. For federal, we have the Section 504 of the Rehabilitation Act and Individuals with Disabilities Education Act, which is the idea that I referenced in our last slide. And for the state, we have Nevada Revised Statutes 388 and 395, and the Nevada Administrative Code, or the NAC, which are chapters 388 and 395. The Section 504 of the Rehabilitation Act is a person with a disability may not be excluded from, denied participation in, or discriminated against by any federally funded program. So a person with a disability could be one of the following: has a physical or mental impairment, which substantially limits one or more major life activities, has a record of such impairment, is regarded as having such an impairment. So the prohibited actions that we were referring to is to deny opportunity to participate in or benefit from aid, benefit, or service, afford unequal access to aid, benefit, or service, provide a different aid, benefit, or service, or limit enjoyment of any right, privilege, advantage, or opportunity. The Section 504 safeguards evaluation and re-evaluations, provision of an accessible, free, appropriate public education, and we'll talk about what appropriate education means in just a bit, access to appropriate services and educational placement, but not a benefit, and due process rights. So here are some of the differences between the Section 504 and IDEA. And I'm going to go through these because it can be a little confusing at times. So for the purpose of law, the 504 is really serving as an anti-discrimination, and the IDEA is 6 principles: identification, evaluation, education, parent participation, and a few others that we'll hit on in that section of the presentation. And then the levels of services between them, the 504 is less detailed and less stringent, and the IDEA is more detailed and more stringent. The qualifications of services will include mental and physical impairment affects that major life activity in the 504. But in the IDEA, it's really just one of those 13 listed disabilities, and the need for special education services. How the service is provided, accommodations in a 504 plan, as we discussed, or it's in that IEP, which is an individualized education plan. And then who provides the services? In the 504, it's really the general education teacher, but in the idea, it could be the general education teacher or a special education teacher. And where are the services provided? The 504 would be in the general education classroom, and then the idea will focus on the least restrictive environment for the child. So the Individuals with Disabilities Education Act is an expansive federal law covering eligible students with disabilities regardless of whether the child is in private or public school, with the limitations in a child is in private school. Now, it's also including the right of the students with disabilities to a free, appropriate public education, also known as FAPE, and related services to meet their individual needs. Free and appropriate public education must be provided to every student with a disability between the ages of 3 through 21. It must be provided without charge, must meet the state educational standards, and should be made in conformity with the child's individualized education program, or the IEP. Earlier, I mentioned the 6 fundamental principles of IDEA, and that is a child-find mandate, non-discriminatory evaluation, appropriate education, least restrictive environment, procedural and due process, and the family and student participation. Now we're going to move into lesson 2, which is the evaluation and eligibility for special education and related services. So who can refer the child for special education services? School professionals, which can include teachers, counselors, administrators, parents, you, the legal guardians, state agency, and state educational agency. How do you go about referring a child for evaluation for special education services? Well, here are some criteria. So notify the child's school that the child is experiencing academic and behavioral difficulties that are adversely affecting the child's educational performance. The notification should be in writing, and then the school has 45 school days to conduct the initial evaluation after the written request is made. Earlier, we mentioned evaluations or reevaluations. So the request for evaluations must be in writing, and the Clark County School District begins with the 45 school day deadline with the signing of Form 555. Now, the initial request should be full and complete because they can be for specific disabilities. Denial of evaluations must also be in writing and be made within 30 days. The assessment requirements for the initial evaluation include the following: assessment of cognitive abilities, social and emotional condition, adaptive skills, health, speech, language, or other communication skills. And how does the child become eligible to receive special education services? The child must meet that eligibility criteria for one of the 13 categories of exceptionality identified by IDEA, and these include autism, deaf or blind, hearing impairment, intellectual disability, or multiple disabilities. And the eligibility requirements are continued here on this slide. So it could also include orthopedic impairment, other health impairment, serious emotional disturbance, specific learning disability, speech or language impairment, traumatic brain injury, visual impairment, or developmental delay. So multidisciplinary team meeting is also known as MTD. And this is really after completion of the evaluation, where the evaluation report is discussed and eligibility for services is determined. And so the MDT team may consist of the following individuals, but it's not limited to the parent and or guardian, the school administrator, school psychologist, special education facilitator, special education teacher, regular education teacher for regular education issues, and may also include a school nurse or related service providers, such as a counselor or physical therapist. So eligibility must be a team decision, and eligibility does not determine services. So getting to the reevaluation, school must reevaluate upon parents' request, but no more than once a year. And 3-year reevaluation must take place unless waived by both the parent and the school, which means every 3 years the child should be reevaluated. Determinations, whether the child continues to have a disability, the present levels of performance and educational needs for the child, whether the child continues to need special education and related services, and whether any additions or modifications are needed to enable the child to meet the goal and objectives identified in the IEP. So FAPE. This is if a child is determined to be eligible for services, the parent must consider or consent prior to services being provided. So the education for a child with a disability must be provided, one, based on the child's unique needs. So that's that defining appropriate, and then at no cost to the parent. And that's why it is free. So FAPE is provided via the Individualized Educational Plan, and initial IEP must be created 30 days after the child is determined to be eligible for services. So FAPE was brought into play and is known as the Raleigh test, and that was a Supreme Court case called the Raleigh case, and it became known for the test for whether a district has provided appropriate education for a child. So under that test, it's a 2-factor test, and it asks these questions. Has the state followed the provisions and or procedures outlined in IDEA? And is the IEP reasonably calculated to enable the child to receive the educational benefit? The Raleigh test is also to make sure that the IDEA does not require the school district to provide the best possible education, but must provide a basic floor of opportunity. And so one of the things to really illustrate that is that FAPE does not require a Cadillac, but it does require a Chevrolet. So the education must still meet the unique needs of the child, but it doesn't have to maximize the child's educational potential. Now, the Endrew Standard under IDEA was enacted to make sure that children with disabilities have access to the curriculum and they make progress. It should be fully inclusive, and the IEP should be ambitious enough for a child to make progress in light of their circumstances. So now let's focus a little more specifically on IEP in Lesson 3. So the Individualized Educational Plan, the IEP, describes the child's needs and determines the proper placement for the child. IEP decisions are determined by the IEP team consensus with parental agreement. Parental rights regarding the IEP process include the following. Prior notice must be provided to parents early enough so they can attend. The meeting must be scheduled at a mutually agreed upon time and place. The IEP meetings are required manually. Parent can request additional IEP meetings as frequently as needed during the school year, and a parent can agree or disagree with the IEP. The members of the required team could be the special education teacher, and the reason is this teacher has experience with special education services and can deliver those. Usually, this is also called the teacher of record, and it's the point person for any request, questions, or revision. And the other required member is the regular education teacher because they must have knowledge of the general education curriculum. Additional members of the IEP team may include the following. The local education agency representative. This is a qualified individual that is able to provide or supervise the provision of services determined by the IEP team, knowledgeable about the availability of resources, And in the Clark County School District, this is usually a special education instructor or facilitator, and or a dean, a principal, or other administrator. Other individuals that could be included on the team are parents, the child. Discretionary members of the IEP team may be invited to the meeting. So other individuals who have knowledge or special expertise regarding the child, including related services personnel as appropriate, deemed by the parent or school. IDEA team member, parent. So who is the parent? What does that mean? Under IDEA, the definition includes biological parents, adoptive parents, legal guardians, person acting in place of a parent, so they may reside with the student with the parent permission, foster parents, and surrogate parents. In this case, agency caseworkers are not recognized as parents under special education law. They can attend meetings and have access to records, but cannot make decisions afforded only to parents. Understanding the IEP. So present levels of performance. How a child is performing currently and how the effects of the disability affect the child's classroom performance. Should include performance in the following areas: academic achievement, language and communication skills, social, emotional, behavioral skills, health, motor skills, adaptive skills, vocational skills, and other skills as appropriate. What's in an IEP? We've talked about who can be on the team. We've talked about what it should include and what it requires. But what's in it is really a measurable annual goal or goals and shorter achievement benchmarks. So this is really a description of how the student's progress toward meeting goals will be measured. The IEP includes the method for reporting the IEP progress to parents. There's a description of specially designed instruction. So what areas the child will receive support in, type of support, how many minutes of support, where the support will be given, rejected date for the beginning, frequency, location, and duration of services. And then supplementary aids and services to help the student achieve the annual goals, such as the OT, PT, assistive technology, and speech and language. Now, justification and explanation of the extent, if any, to which the student will not participate or be placed, which is placement, with non-disabled students in the general education. And last but not least, the statement of accommodations that are needed to measure the student's achievement on statewide assessments. Now, FAPE in the IEP. So at 14, there's a bit of a transition, and the IEP should contain goals and classes that prepare a child to transition to adulthood. So starting when the child is 16 and updated annually, the IEP must include a statement of transition services needed of the child. So these services can include the following and will vary child to child, but colleges, community colleges, vocational training, independent living, or community participation skills. Transition services can include both work and life skills, and services are to be based on the individual student's needs, taking into account the student's preferences and interest. Now, lesson 4 is really going to focus on placement and processes. So the fundamentals of placement include special education services must be provided in a child's least restrictive environment, meaning if the child is able to receive instruction in an environment that includes other children or in their regular classroom, then we don't want to remove them from that classroom or remove them from other students just to provide those services. Placement should be based on the child's IEP and unique needs. Placement consideration must start with whether services provided in the regular education classroom with any needed support. If child needs to be pulled out, it needs to be justified and should only be for areas or the time necessary. And placement may not be based on the child's disability category. So we have a continuum of placements. So we have the least restrictive to the more restrictive, and the more typical peer interaction to the less typical peer interaction. And so if you'll remember from section 1, that least restrictive and more restrictive, that has to do with some of the differences in the 504 to the idea. But we have the regular classroom, and that may be with resource pull-out support, to the specialized classes for some or all of the child's school day, to special schools, to hospital institution, or homebound. So it can definitely vary on that continuum. The least restrictive environment, to the maximum extent appropriate, children with disabilities are to be educated with students who are not disabled. So removal may only occur when special education in regular class with the use of supplementary aids and services cannot be achieved satisfactorily. Inquiry starts with regular education classroom. Factors to consider in LRE determination include the following: potential harmful effect on the child or on the quality of services needed, proximity to the child's home, age appropriateness, all possible accommodations and modifications that could be provided in the regular classroom. Inclusive practices include some of the following examples: environmental adaptations, so preferential seating, planned seating on the bus, in the classroom, at lunch, in the auditorium, and in other locations, or altered physical room arrangement. Another example is additional or supplemental staff, consultation or direct interventions by specialists, classroom one-on-one, extra assistance, pushing the teacher. Planning time for collaboration needed by staff, and modified work at instructional level. And so the child works on their task at his or her level in the subject area in regular education class. A few more examples are specialized equipment. So movement devices, computer, iPads, software apps, communication device, utensils, cups, plates, adaptive OT devices for that occupational therapy. Pacing of instruction or work. So breaks, more time for the work, having the ability to check for understanding, or chunking assignments into parts. Alternative modalities of material presented. For example, maybe the lectures are taped, or they're provided in sign language, or in the child's primary language. In addition, they can be paired with reading and writing. Supplemental materials. Maybe there's a set of materials that are sent home. Scan tests and notes into the computer. Shared note-taking, large printer braille, or assistive technology. So lesson 5, a little bit more about parental rights. So parental right, prior written notice. What that means is the district must provide parents with prior written notice whenever it proposes or refuses to initiate or change the identification, evaluation, or educational placement of the child, or the provision of FAPE to the child. So basically, if it wants to make a major change within an IDEA provision, that's when the written notice, prior written notice, would be required. Now, notice must include a description of action proposed or refused, an explanation of why the district proposes or refuses to take that action, and a description of each data source the district used as a basis for the proposed or refused action. Parental rights also includes participation and consent. So informed parental consent must be obtained before initial evaluation and initial special education placement. School districts cannot override lack of parent consent for initial placement. Districts can only initiate due process hearing to override lack of parental consent. So if the parent fails to respond to the school district attempts to obtain consent before reevaluation, the school district may proceed without consent. A parent is entitled to be informed of any special education meetings, and meetings must be scheduled at a mutually agreed upon time. If the parent fails to respond to several attempts that are documented, including phone calls, written letters, etc., by the school to ensure participation in an IEP meeting, the school may proceed with the meeting without the parent present. And parents may remove their child from special education altogether. School districts can no longer seek due process hearing to override parental removal. So for your access, amendment, and confidentiality of records, parents' right to inspect and review educational records include the right to a response from the school district to reasonable requests for explanations and interpretations of the records, a right to inspect or have a representative inspect and review records, and right to request copies of records containing information regarding the student. If the parent believes that information is inaccurate or misleading or violates the privacy or other rights of the child, he or she may request that the school district amend that information. The school may charge for copying school records, and confidentiality of records is maintained through Family Education Rights and Privacy Act, or FERPA, and discussed in IDEA. The procedure remedies for disagreement. The parent right is for evaluation, the independent educational evaluation, or the IEE. So the parent may request independent educational evaluation at public expense if the parent disagrees with the school district evaluation. But the school district must fund the IEE or initiate a due process hearing, and the hearing officer then determines if the parent is entitled to payment for IEE. So identification, FAPE, IEP placement, it could be through state complaint, due process, Office of Civil Rights complaint. So here are some of the examples for the type of violation, whether it be a state complaint, a due process complaint, or Office of Civil Rights complaint. It explains the required content for each one, how you would file with the individual complaint processes, the time frame that it must be filed within, the general process of what to expect, and then the remedies for the state complaint, due process complaint, or Office of Civil Rights complaints. So we do have a list of available resources that you can check out for additional information and use at your leisure. Again, we hope that now that you have gone through this training, you know important terms like FAPE and IEP, that you have an idea of what's in an IEP, who's on the team, how is it created and what it does, that you have an expectation of how the placement and practices work, and most importantly, that you understand your safeguards and your parental rights. Thank you for your time today that you have spent with the Legal Aid Center of Southern Nevada and the UNLV William S. Boyd School of Law. We appreciate your time and hope that this information in this free legal course was absolutely resourceful and helpful to you regarding special education. Thank you so much.